but by the material facts. International judicial system before rendering justice with consciousness, common sense, this ingredient is essential. The decision must relate to the facts of the case. The proposition is not governed by all the facts but by the material facts. Then we are going to tool of study of Goodhart test. The Professor Goodhart, though American, has spent most of his professional life in England and was professor of jurisprudence at Oxford. He renders these following steps. First step is in Goodhart test, the principle of a case is not found in the reasons given in the opinion. Second one is the principle is not found in the rule of law set forth in the opinion. Third one is the principle is not necessarily found by a consideration of all the ascertainable facts of the case and the judge's decision. Fourth step is the principle of the case is found by taking account of facts treated by the judge as material. Second limb is his decision as based on them. This is called as a ratio decidency. That means material facts plus decision. Ratio means material facts. Decidency means a decision. So material facts plus decision resident. The ratio and principle of the case have been used as if they are interchangeable. This is fourth step. Fifth step is in finding the principle, it is also necessary to establish what facts were held to be immaterial by the judge. For the principle may depend as much on exclusion as it does not as does on inclusion. Finally, the ratio can be referred to four elements. Number one is first element is it is a rule possessing generality. Second element is it is a rule or principle stated in a previous decision. All statements of the rule are binding. The fourth element is the legal principle stated is interpreted literally except that it can be narrowed by distinguishing or expanded in scope by the second court. Once again, I tell to find out before passing judicial precedent, we should apply these tools of study in legal research methodology of Professor Goodhart, that is called as a Goodhart test. Five steps are in Goodhart test. First step is the principle of a case is not found in the reasons given in the opinion. Second step is the principle is not found in the rule of law set forth in the opinion in previous judgments. Third one is the principle is not necessarily found to be a consideration of all the ascertainable facts of the case and the judge's decision in previous cases. Fourth one is the principle of the case is found by taking account of the facts treated by the judges as material only or his decision based on them only. Ratio decidency, material facts plus decision. But here ratio and principle of the case have been used as if they are interchangeable. Fifth step is in finding the principle, it has also necessary to establish what facts were held to be immaterial by the judge. For the principle may depend as much on exclusion as it does on inclusion. In Goodhart test, fifth step is whether the previous judgment and its ingredients, and by applying these four steps, the judges should come to the decision. In finding the principle, it is also necessary to establish what facts were held to be immaterial. Facts which are all immaterial should be considered with common sense and by the judge. For the principle may depend as much on the always the settled legal principle for judgments is always depend as much on exclusion of any one of the legal principle, or it comes under depend on the inclusion of one legal settled legal principle. So by using Goodhart test in fifth step, the judges apply the common sense and come to the conclusion whether we should do the exclusion of settled legal principle in previous judgment and overruling and by rendering precedent, or otherwise we should include the another legal settled principle which is not included previously and overruling and was the president. Finally, the ratio can be referred to four elements. That is, it is a rule possessing generality. That rule should be possessing generality. Second ingredient is it is a rule or principle stated in a previous decision. Third is all statements of the rule are binding. Fourth one is the legal principle stated is interpreted literally, except that it can be narrowed by distinguishing or expanded in scope by the second. These are all to be considered before applying the Goodhart test in legal research methodology tools of study to uh, reject the null hypothesis and establish our hypothesis. Next one is obiter dicta. In Latin, obiter dicta, um, it literally it means said by the way. Said by the way. It's a remark or observation made by a judge that, although it included in the body of the court's opinion, does not form a necessary part of the court's decision. In a court's opinion, obiter dicta include but are not limited to words introduced by way of comment, illustration, or analogy or argument. Thus, the judge, in explaining his ruling, may provide a hypothetical set of facts and explains how he or she believes the law would apply to those facts. The quieted passage of obiter dicta may become part of the holding or ruling in a subsequent case, depending on what the later court actually decided and how that court treated the principle embodied in the quoted passage. The arguments and reasoning of the dissenting opinion also constitute obiter dicta. Woodward definition of obiter dictum is simply a conclusion based on a fact existence of which has not been determined by the court. Decisions sub silentio is not binding the same level court. Decisions sub silentio. There is a clear difference in obiter dictum and sub silentio. Both are help to find out the judicial precedent. In Goodgar's definition of obiter dictum is simply a conclusion based on a fact existence of which has not been determined by the court. In decisions, sub silentio is not binding the same level court on the ground that a particular point had not been perceived or discussed by the court while deciding the case earlier. The airline difference is, for example, lower hierarchical court is decided without considering on legal principle. Then Supreme Court or higher apex court is deciding. That time